Good afternoon, my ladies and lords. I was going to take you
authorities.
through... not at all. I was going to take you through the authorities that I've cited in my certain arguments, starting, and I hope really very briefly, with Minute and Morgan, because what I get from this, my ladies and lords, is simply the fact that the sort of circumstances that might arise under the successor entitled principle are quite broad. And the other thing I get from this judgment...
I'm sorry, where are we? 21.
21.
Thank you.
The other thing that I get from the judgment of the law itself is the unrestricted way in which he expressed the principle, or at least it doesn't seem to have been even the subject of argument in this case, and is referred to only clearly in the head note. This was a case where, as the head note shows, a claimant claimed privilege over some documents relating to a property. In fact, it was correspondence between himself and solicitors and his mother, who was his predecessor in title, and solicitors. And the question arose whether or not the main question that arose was whether or not that claim to privilege was properly claimed in the affidavit claiming it. And my ladies and lords, if I could just draw your attention to the claim itself at page 429 of the bundle, that's 362 of the judgment. Just at the second hole punch, one sees the description that was in the affidavit there. He further stated that by the description, correspondence between the plaintiff and his predecessors in title on the one hand, and his and their solicitors from time to time on the other, he had meant correspondence between himself and his family solicitors and his present solicitors in this cause, written in contemplation or in the course of this suit, or with reference to the subject matter in dispute, and letters between his mother and her solicitors, with reference to the questions connected with the matters in dispute. And it's that latter part that is the, as it were, the inherited privilege. And I take it that that's what happened here. It's correspondence between probably the claimant's late mother. I don't think the report is very clear as to how the title moved from mother to son, but one sees the broad way in which it is made, simply because he is the successor in title to his mother. He's entitled to claim privilege over the correspondence between his mother and her solicitors. And as I say, Lord Selborne's judgment, the only part of it I would draw your attention to, my ladies and lords, is page 366. Sorry, 366 of the judgment. Just around about the second hole punch, the paragraph that begins, the only question is. And he answered the question is in the affirmative at the end of his judgment, and Sir George Mellish agreed. Page 436. So I can move on from there to Pickering, In re Pickering case, which is tab 19. Now I should say straight away, my ladies and lords, this is not a privilege case. This is a case of a son succeeding to his father in a partnership and then wanting access to documents on disclosure in a claim against the other partner, which was, I think, the brother of the deceased.
So this is a successors in title case as opposed to a privilege.
Absolutely, absolutely. And the reason I cite is, again, it shows the sort of circumstances where this situation might arise. And although one doesn't deal with, as it were, the privilege, what the Court of Appeal held in this case was that because the claimant was a successor entitled to the father, or was, as they put it, interested in the partnership in the same way, therefore the rules as to disclosure applied equally to this case as they would do if it was a claim by a partner. And one sees that not only from the head note, the holding, affirming the decision of Mr Justice Chitty, but also from the judgment of Lord Justice Cotton at page 249, again at the second hole punch, with the beginning of the words, but in the present case. So if I begin just at the sentence before, two sentences before, the only real question is whether he ought to be at liberty to seal up some portion of the letters entered in the letter books of the partnership, the common form of order gives the party producing his books liberty to seal up such entries as he swears do not relate to the matters in dispute in the action. But in the present case, as between the plaintiff and defendant, these books are not the books of the defendant, but the books of the partnership, in which the plaintiff, as well as the executors of the deceased partner and the surviving partner, have an interest. And that's the critical distinction in that case, which I rely on. The next case is the Crescent Farm case itself, which is tab 17. And then, friends, shown you some parts of this, which I won't show you again. In short, this was a case where, I think Malone Friend showed you, there was an act of sale of property. In fact, it was some land, and which might or might not have had planning permission. And so I think Malone Friend showed you that the nature of the transfer. So I won't show you that. But what I would show you is what was actually claimed in terms of privilege. It's at page 393 of the bundle. That's C. Between B and C. The claim for privilege is so made in their list of documents in these words. Such documents consist solely of professional communications of a confidential character passing between the first named defendant solicitors and its counsel for the purposes of obtaining legal advice in relation to the title to land now vested in this defendant. So it's fair to say that the claim for privilege in this case was quite a narrow one, rather than the more general one to an entire file, and that one can distinguish that from the later cases where the successor in title has obtained access to the entire file, which is more, I suppose, in line with what we say has happened in this case. But that did not seem to be doesn't form any particular part of the reasoning of the learned judge, Mr. Justice Goff, at F on page 393, where he simply expressed the principle as being, in his words, clearly established, and referring to Hallsbury's and then the Minette and Morgan case that I referred to before. And he referred to it being unequivocally expressed in the second part of the head note, which I've shown you, my ladies and lords. And then he referred to other cases which also established the principle. Over the page at 394, a case of Mostyn and West Mostyn Coal at C. And there's a reference there to Mr. Justice Lindley's judgment, where after referring to Manser and Dix in 1855 and Minette and Morgan, at the end of the paragraph, there's the sentence beginning, as to Mr. Clark. As to Mr. Clark, there may be more difficulty, but he was negotiating for a lease and got the agreement transferred to the company. So substantially, there was a lease to Clark, and in substance, the company are successors in point of beneficial title to Clark. So one sees, again, the range of sort of circumstances where this principle might apply. In this case, a transfer of a lease to a company from an individual. And then there's a reference to Holcraft and Guest, and also Schneider and Lee. And Lord Justice Hodgson's judgment in the latter case, where he emphasises that the privilege is the privilege of the company, subject to the qualification that the privilege inures for the benefit of successors in title to the party to an action, at any rate where the relevant interest subsists. So what one sees there is the application of the principle, my ladies and lords, to a situation which is much closer to the present one, namely to an action, where somebody's bringing an action and they may wish to claim the privilege relating to documents relating to that action. I don't think one gets an enormous amount further from this judgment, although it's often cited as I think the leading authority, even referred to as the Crescent Farm principle on this particular area of law. But what I would submit to you is the following: that the way the principle is expressed and applied in this case isn't in a limited way specific to the particular claim being made, albeit that there was a narrow claim for privilege in this case. One sees that it's expressed in general terms and in a range of different circumstances, with the title to the relevant asset being passed in a range of different ways. That's what I'd be this. The next authority in my chronological list is the Aegis Blaze. Now, I've referred this to my ladies and lords, because it is cited in some of the textbooks as being a good illustration or a leading illustration of the principle. This is in 1985, a case involving, as the name might suggest, a claim by cargo owners against ship owners. This is in tab 16.
Thank you.
Now, I should also say, this was a claim for privilege, but it wasn't a claim for privilege by a successor in title. So it was the opposite, if you like, of the position in Pickering. And in this case, the reason I refer to it is that...
a claim for privilege against the successor in title?
No, this was a claim for privilege by the ship owner in relation to documents that had come, in particular a report, that had come into existence in the course of some earlier claims. Right. So it didn't actually involve the successor in title at all, on either side, as it were. But the reason I cite it is because it's another applicant or statement by the Court of Appeal of the principle in general terms, and one sees from the head note, the first holding, that there's a reference there to Schneider and Lee, and then in the second holding there's a reference to Holcroft and Guest. So I won't take you to any of the detail, but I just refer you to where the principle is expressed as a one in general terms, page 397 of the bundle, on the left-hand side.
What page?
Page 379, I beg your pardon. On the left-hand column, this is dealing with the Holcroft and Guest case, where there's a summary at the end. In particular, it's the last sentence of the second paragraph there, where Lord Justice Parker says this: he therefore upheld a claim to privilege by a successor in title in respect of documents which had been obtained by a solicitor for the purposes of an action 120 years or more previously. That gives one a flavour of the nature of the case in that case. I think that's to do with fishing of some sort.
They have long memories, fishermen.
Yes, exactly. And then on the right-hand side, there's a reference to Schneider and Lee.
Yeah.
And it's at the passage, I think I've highlighted it on the second hole punch. Again, page 380, my ladies and lords, on the left-hand side, again, I've highlighted it. I don't think I need to do more than also mention 381 on the right-hand side. There's a sort of summary of the principle where Lord Justice Parker says this: those cases, Holcroft and Guest, Bullock and Corey, Pearson, Fisher, Foster, appear to me to establish clearly that although the privilege which prevailed in the first action may only be claimed in a subsequent action by the person originally entitled to it, or his successor, there is no other requirement such as is advanced here by the respondents. So I can move on from that to, I suppose, the first modern authority which deals very clearly with the joint privilege, which is the Königsberg case. That's tab 14. The context, my ladies and lords, was the transfer, as one sees in quite a lot of the bankruptcy cases, the transfer of a matrimonial home from a husband and wife's names jointly to the wife's sole name. In this case, as one sees from the head note, in consideration of love and affection. Perhaps unsurprisingly, the year after, when the husband became bankrupt, the transfer was challenged by the trustee in bankruptcy, and then under the 1914 Act, section 42 of that Act, as a voluntary transfer, as it's called, presumably a sort of transaction of an undervalue equivalent. In that case, as one sees also from the head note, the bankrupt's wife, in response to the application, put in evidence and correspondence with the solicitor who'd been instructed on the sale, and then the trustee in bankruptcy apparently obtained a witness statement or an affidavit from the solicitor in question, which rather contradicted the account which the wife had given. So it was an application by the wife to exclude that evidence on the grounds of privilege. And we know that the claim from the head note that the claim failed, that application, on two grounds. First of all, waiver, secondly, on succession of the joint privilege to the trustee in bankruptcy. Now, as regards, certainly the first part of the judgment still stands, but the second part is obviously the relevant part for present purposes. And if we pick up the judgment at page 355 at D, one sees there the submission that was advanced on behalf of the trustee in bankruptcy that Mrs. Königsberg couldn't assert privilege for three reasons. The first one was that one joint client cannot claim privilege against another joint client in respect of communications by a solicitor for both joint clients. So that's
very reading from
at page 355 and D of the judgment.
Oh, sorry, the middle bit.
Yes, that's
Yeah,
right.
sorry. Yes.
Mr. Justice Peter Gibson's judgment. So that was the argument. The judge deals with those in turn, and at page 357, again at D, Mr. Justice Peter Gibson rejects or holds that Ms. Königsberg had waived privilege, and then he starts his analysis of the second point just above H on the same page, and where he sets out the principles relating to joint retainer, none of which are in dispute. And at page 358, at C, he recites Mr. Lammy's submission, namely that he didn't challenge the general proposition as applicable were the bankrupt to be suing Mrs. Königsberg, but as he rightly pointed out, the crucial question is whether the trustee can be said to stand in the shoes of the bankrupt for the purposes of the rule, or whether the trustee is to be treated as a third party. So, my ladies and lords, the question there wasn't the same argument wasn't advanced as it advanced by my learned friend. It was accepted, in short, that the successor entitled principle would apply where there was a joint privilege. And the only question that the court then addressed, what was described as the crucial question by the learned judge, was whether the trustee was a successor entitled. And that was the issue. Just below D, the trustee is no ordinary third party. There's a reference after that to the successor entitled principle, a reference to the Crescent Farm case, and at G, the learned judge says this: the distinction that is drawn is between privilege relating to the bankrupt's property, divisible amongst his creditors on the one hand, and to property not so divisible or to matters personal to the bankrupt on the other. So it's put very much in the context of property and who is the person entitled to that property. And then over the page 359, this is the concession that Mr. Lammy made, that he accepted at A, that because of the transfer in 1985, he accepted that the bankrupt came under an obligation under the latter section, and he accepted that the relevant privilege of the bankrupt had devolved onto the trustee. So that concession having been made, in other words, that the trustee stood in the shoes of the husband, Mr. Königsberg, then the judge applied the principle, the successor entitled principle, at E to a joint retainer case, where he said this: I can see no sufficient reason to treat the trustee as the third party for that purpose. The rule recognises that joint clients cannot maintain privilege against each other, and as the privilege of the bankrupt had devolved onto the trustee, who is entitled to obtain the privileged information from the bankrupt, in my judgment it's appropriate to treat the trustee as being in the shoes of the bankrupt for the purpose of privilege in proceedings against the joint client. So it's precisely that situation that I seek to rely on, albeit in the context is not where the successor is not a trustee in bankruptcy, the successor is an assignee of a claim and a cause of action. But I draw that to your attention because it's only the part of the judgment that deals with the concession that was made by Mr. Lammy that's been overturned in the Court of Appeal. It's not the analysis that the successor entitled principle applies to joint retainers, albeit that I accept that there wasn't a lot of argument in this case about that point. I've shown you the judgment and how the judge dealt with that particular point. Certainly he considered that if the trustee was a successor, then he would stand in the shoes of the joint client, in this case the husband. So that's the...
Hold on a minute. Let me just make it. So the bit that's overturned in Schlossberg is the concession, effectively at the top of page 359.
Indeed.
That the trustee in bankruptcy was the successor.
Absolutely, yes. And I'll take my ladies-in-law to the Schlossberg case in a few minutes' time, but it will be my submission that effectively that's a case that turns on the interpretation of the Insolvency Act rather than anything else. So I've shown you Königsberg, and the next case I'd like to show is the surface technology case, because that is the application of the principle, the successor entitled principle, in the context of a joint retainer case, but not a bankruptcy case. That's at tab 12. It's also of relevance in the light of my own friend's submissions, because this was the case where what was the privilege to which there was a succession, as it were, related to whole solicitor's files, not particular documents within those files that related to a particular claim. One doesn't need to do an analysis of the pleading in the way that my own friend sought to do in order to determine in my submission precisely which documents one's going to talk about, but actually it's the succession to title, which then puts the person, the successor, in the shoes of the predecessor as regards the whole file, rather than a bit of it. The head note would show that, this is just at H2, that the main argument in this case was whether or not, under the terms of the agreement that the claimant entered into with the administrative receivers of the company, Ultraseal, whether or not they obtained title to the intellectual property which gave them the right to bring the claim. And this was a case where just before the second hole punch, as the head note shows, that the second claim contended that by the sale, it had acquired the whole business and undertaking of Ultraseal, including the patent and certain know-hows relating to the sealant compositions. And one sees at the top that this was a claim for declarations relating to those patents. And the defendant's position was simply that there was a license to the company, so that the company wasn't actually the owner of the patents in question. Now, what's significant here, this was a case of joint and sole retainer files. Ladies and lords will see that at H3, 5 lines down, the sentence beginning, the firm instructed. The firm instructed that's Berrymans, by the way, had in the past acted for Ultraseal International when it was a subsidiary of the second defendant, and on various matters connected with its business. In some cases, the instructions have come solely from Ultraseal International, and in others, jointly from that company and from its parent, the second defendant. So one sees the breadth of the files there that were an issue in this case. And the holding at page 330 of the bundle, at H7, was that what had been transferred to the claimant by the asset sale was the intellectual property, insofar as title subsisted to it, including the patents, if the vendor company had owned them. And to that extent, the claimants as successors in title to Ultraseal International could claim legal professional privilege as against the defendants in respect of all matters on which the solicitors were solely instructed by Ultraseal International, and could claim joint privilege in respect of all matters upon which the solicitors had been instructed jointly by the company and its parent. So one sees the breadth there of the application of the principle. It's Mr. Justice Humphrey's decision, and his judgment, the relevant part of his judgment begins at page 336 of the bundle, paragraph 14. And the particular files in question are identified in paragraph 15, my ladies and lords, at the end of that paragraph. Sentence beginning, 5 lines up, of the files still in existence. Bird and Bird consider that they were solely instructed solely by Ultraseal Guernsey in relation to one matter, that's not relevant, solely by Ultraseal UK in relation to 5 matters, that is relevant, and jointly by Ultraseal UK and Ultraseal Guernsey in relation to 7 matters. So those were the files. And then at paragraph 17, one sees the submission of the claimants, 3 lines down. They say that as successor entitled to Ultraseal UK, Norman Hay plc and its successor entitled Surface Technology plc, they are entitled to the benefit of the privilege attaching to the files which record the instructions received by Bird and Bird, the advice which they gave, and other matters which form part of the file and would be privileged on the principles of the well-known case of Bellabell and Arrington. Insofar as instructions are given solely by Ultraseal UK, they say they're solely entitled to the privilege and can therefore require the documents not to be disclosed to any other person. And insofar as the instructions are given jointly by Ultraseal UK and Ultraseal Guernsey, they say they're entitled to a joint privilege with Ultraseal Guernsey, and then we don't need to deal with the other category. And the analysis of the learned judge begins at paragraph 19, where he says this: I'll take the points in the order starting with privilege. It seems to me that to follow from the decision of Mr Justice Goffin, Crescent Farmers Sports against Sterling offices, that the successor entitled to identify property is entitled to assert the privilege of the vendor, at least in respect of documents prepared for the purpose of obtaining legal advice in relation to the property transferred and in relation to the advice given. And then he sets out what happened in that particular case and the references to the various authorities that I've shown you in paragraph 21. And then at paragraph 22, Mr Justice Pumphrey says this: the principle has been followed more recently by Peter Gibson, J., as he then was in Königsberg. And then he sets out what happened in the Königsberg case. So what he's doing there, in my respectful submission, is Mr Justice Pumphrey is identifying the application of the successor entitled principle to a joint retainer case in Königsberg. Of course, Königsberg happened to involve a trustee in bankruptcy, but that was irrelevant to this case. Then at page 340 of the bundle, paragraph 25, Mr Justice Pumphrey says this: obviously the first question is what was transferred to the claimant in this case. Undoubtedly, it seems to me, the intellectual property insofar as title subsisted to it, including the patents if the vendor owned them. So it seems to me that the claimants can claim privilege to this extent. I would hold also that it's implicit in this proposition that the claimant is entitled to copies of the privileged material from the solicitors at its own expense. This follows, it seems to me, because otherwise the privilege is valueless, since the claimants have no means of knowing what material they're asserting privilege in. And then this: it seems to me that this follows from the existence of the privilege itself and not from any entitlement to the documents in question under the agreement. Now, I draw that to your attention in the light of my learned friend's submissions. Yes, because this was a case where, as this part of the judgment shows, there was a specific provision dealing with access to documents and whether or not there'd been an acquisition of the documents themselves under Clause 8 of the agreement. And what Mr Justice Pumphrey is saying is that the entitlement of a successor entitled to property to stand in the shoes of the predecessor as regards privilege is something which exists independently from any contractual entitlement. It's simply a question of law, not contract. Obviously, one has to be satisfied that the person has acquired the title in question, but once the court is satisfied that the person has acquired the title, in this case to patents, then the principle of law follows. And paragraph 26, Mr Justice Pumphrey dealt specifically with the question of the joint privilege. And about halfway down the paragraph on the right-hand side is a sentence beginning accordingly, where he says this: accordingly, in my judgment, the claimant is entitled to claim the privilege as against the defendants in respect of the Bird and Bird files, in relation to which Bird and Bird was solely instructed by Ultraseal UK, and the position as stated by Peter Gibson in Königsberg in relation to the matter which is jointly privileged obtains here equally. As I say, my ladies and lords, that's the application of that principle, not in the context of a bankruptcy case, but it's just an unusual case such as we have here. So that's surface technology, and I submit that that is a direct authority in support of the proposition that I cite in my skeleton argument. I also rely on Königsberg, but subject to the limitations that I've already identified. We can go from that case to the Schlossberg case. My learned friend took you to quite a lot of this, so I won't repeat it. That's tab 9. I agree with my learned friend that this was a case involving, in some part, sole privilege, that's relating to the CAT claim, that's the right way of describing it, but also some joint privilege as well, in relation to the winding up proceedings, etc. Again, these were documents in a solicitor's file, and there was no attempt to try and distinguish between particular documents in that file and whether or not they related to the particular claim that was being made. The claim was as a successor entitled to the whole file as a result of a transfer of title pursuant to the provisions of the Insolvency Act. Now, I think what I would just show you is, first of all, very briefly, in the judgment of Mr. Justice Arnold, a first instance, whose decision was upheld, at page 199 of the bundle. One sees from this, under the heading, the authorities on privilege, Mr. Justice Arnold carried out a fairly comprehensive analysis of the previous decisions in relation to successors in title, including 72 Crescent Farm, 73 Königsberg, and 81 Surface Technology. We also looked at a number of other cases as well. And one sees, my ladies and lords, at page 211, that the argument that was addressed to him in the first argument, as it was called, was whether or not the trustee was the successor entitled to the pieces of paper. That argument did not, unsurprisingly, succeed. The second argument, which is at page 212, was whether or not privilege was property within the definition of the Insolvency Act, or a power over property. And his lordship held that it wasn't. And that chimes with Mr. Justice Aitken's later finding that privilege isn't something that you assign, it's something that you own as a matter of property. You assign the title to the property, but it's a question of law whether or not privilege is something that you can rest. The third argument at page 214 was whether it related to a specific asset, or at least alleged asset of the estate, namely a particular claim in the county court. That part of the judgment, which wasn't appealed, proceeded on a concession. I don't need to trouble my ladies and gentlemen in relation to that. The nub of it was the fourth argument at page 215, and it related to the liabilities, namely particular judgments that have been obtained against Mr. Schlossberg, and whether, because they were judgments against him, the obligation, as referred to in paragraph 134 of the judgment, was an obligation that gave rise to property that was vested in the trustee. An odd claim, counterintuitive, that a liability would be a property which is vested in the trustee, and it's a claim that wasn't accepted, as my lords and ladies see at paragraph 141. Paragraph 143 sets out the claim to privilege. One gets from that, again, that there was a joint privilege as well as a sole privilege. I don't think I need to show you anything more than that before I go to the Court of Appeal judgment. And this is Sir Terence Petherton's Master of the Rolls' judgment that my learned friend already took you to. Now, what I show you here, and I've shown you those different categories of different arguments for this reason. One sees that they are tied very distinctly to the provisions of the Insolvency Act. What was being suggested was that under the terms of the Act, the effect of those provisions was to vest particular assets and liabilities in the trustee in bankruptcy. And it was in that context that the argument about successor in title arose. And that's important because both Mr Justice Arnold and also the Court of Appeal held was that the trustee in bankruptcy simply wasn't a successor in title. And that's as far, in my respectful submission, as the judgment goes. What is interesting as well, and I've shown you that in some detail, is that this was a case that involved joint privilege. And neither at first instance nor in the Court of Appeal was any suggestion made that the principle of successor in title just didn't apply to joint privilege at all. I mean, if that had been the case, that would have been a short answer to the point in relation to categories B and C. But it wasn't. The point wasn't taken. The court proceeded on the basis that the successor in title principle could apply to these documents that were jointly privileged, and that, although it's not an express part of the judgment, is something that I also rely on. So that the part of the judgment that I would just refer you to, Mr. Terence Etherton, Master of the Rolls, is paragraphs 53 and 63. At 53, the Master of Rolls said that he didn't accept that privilege was property which vested in the trustees. And that just repeats the submission that I've found, or supports the submission that I've just made in relation to that. Over the page 233 of the bundle, starting at paragraphs 59 onwards, one sees that the Master of Rolls looks at some of the judgments that were referred to below. He looks at, in particular, Crescent Farm and paragraph 59, and in that regard, Minute and Morgan further down at E. And then paragraph 60, he looks also at Re Koenigsberg. He doesn't look at surface technology. And what he finds at paragraph 63 is that on the proper interpretation of the relevant provisions of the Act, privilege is not property of the bankrupt, which automatically vests in the trustee.
Well, he wouldn't have needed to look at surface technology because it wasn't an insolvency
Absolutely.
case.
That was That was my implicit submission.
Sorry,
no, my lord,
I was just trying to work out. I wondered if you were suggesting that Sir Terence in some way nodded, but in fact you're saying no, he had no reason to look at surface.
Indeed, absolutely. And so when one looks at paragraph 64, which is what my learned friend relies on, in my submission, one cannot get from that any criticism of the surface technology case, because it simply wasn't considering it. What he holds in that paragraph is that the two cases that the three cases that I've just referred to, namely Crescent Farm, Minute, and Koenigsberg, none of those stand in the way of his finding. And then, so when the Master of the Rolls at the bottom of that page uses the words, it's not correct on the point presently under consideration, referencing Koenigsberg, the point under consideration is whether or not the privilege inures for the benefit of a trustee in bankruptcy, not whether, for some reason, it applies to the question of joint privilege. Now that holding and that interpretation of the holding, I submit, is supported by the Leeds and Lemos case that my learned friend referred you to. I don't propose to spend much time in this. It's at tab 7.
So in Schlossberg, it turned on the point as to whether, as he puts it, on the proper interpretation of the relevant provisions of the 86 Act, privilege was or was not property of a bankrupt, which automatically vested in the trustee.
Absolutely.
So it's an insolvency point.
Absolutely. I'm grateful. And just on the question of what the Master of the Rolls was dealing with, and in that last sentence, there's some assistance in my respectful submission that one can get from Leeds and Lemos, but in essence, Leeds and Lemos is simply an application of Avonlea. There was some argument in Leeds and Lemos as to whether or not the principle that had been established related to both assets as well as liabilities. The reason I showed you in some depth Mr. Justice Arnold's judgment was that you recall there was a concession in relation to assets, but not in relation to liabilities. So that concession allowed counsel, in this case, Leeds and Lemos, to argue that the principle did not apply to assets, only to liabilities. And the holding of Judge Hodge is that it applies to both, because it's in the context of what he described as an involuntary passing of title. And he distinguished an involuntary passing of title from a voluntary passing of title, which is what we, the court has before it today, in our case. And just to make good that point, if my ladies and lords will go to paragraph 220 of the judgment. Page 158 of the bundle. Paragraph 221, Judge Hodge QC says this: given the Court of Appeal did not endorse Mr. Justice Arnold's view that the involuntary transfer of privilege did not involve an abrogation of privilege, I consider that Arnold J's decision, insofar as it was a decision at all, and not simply based on the way in which the case was argued before him, is no authority for the proposition of the Crescent Farm principle in personal insolvency cases. So that is, as it were, casting aside the fact that the result was different at first instance in the Avon case. And then over the page, at page 159, at paragraph 232 of Judge Hodge's judgment, he says this, and this is relating to the last sentence. He says, I do not consider that Ciceron's observation that in Reed Königsberg was not correct on the point presently under consideration was confined to liability documents. In my judgment, the point under consideration was whether the premise upon which Peter Gibson J's decision was founded was correct. The premise was that the trustee in bankruptcy had stepped into the shoes of the privilege held by the bankrupt. I suggest that supports the submission I made before as to the correct interpretation of Avon. And then finally, on this particular case, I would draw your attention to paragraph 242. I'm satisfied on a true reading analysis of the Court of Appeal's decision in the Avon case that the Crescent Farm principle has no application in bankruptcy, even in relation to asset as well as to liability documents. I am satisfied that there should be no distinction between the two classes of documents. That's the central holding of the case. And then finally, in support of what I submitted a few moments ago, page 161, paragraph 244 of the judgment, Judge Hodge makes clear as follows: I in no way question the Crescent Farm principle in the case of a voluntary passing of property in assets, although I point out that even on that basis, the Crescent Farm case is no authority on the issue of who has the right to waive privilege in such documents as distinct from asserting it. But I'm satisfied it has no application in the case of the passing of property to a trustee in bankruptcy, and that insofar as Peter Gibson J held that it did in Reed Königsberg is wrongly decided. So I submit that that does assist the court, both in terms of understanding what survives in terms of those first instance decisions and what does not survive, in answer to my friend's submissions in relation to that you don't get any assistance from those earlier cases, but also as to the distinction between a sole privilege case and a joint privilege case, because of course in a sole privilege case, the successor in title has the right not only to access the documents, but also to waive any privilege, because it's his sole privilege. But of course, in a joint privilege case, the person who succeeds is entitled to access the documents, but he is not entitled to waive the privilege. And that's exactly the position that applies in my respectful submission here. But Hugh James Invo Legal, as the successors in title of the joint privilege of Transform and Travelers, are entitled to access the documents, but they are not entitled to waive those documents. They are under exactly the same restrictions as would apply to Transform. And that's exactly what the judge held in his judgment, in my respectful submission. And when he refers to benefit and burden, and when Mr. Justice Aitken does as well, that's what they're referring to. It's that point that when you succeed to a joint privilege, you can't waive the privilege, but you are entitled to access the documents. Finally, on this run of authorities, I would refer to the twin benefits case, which is tab 8. Now, this is another case where there wasn't a lot of argument, I accept, here, but it's it's a persistence in that it shows post-Avonwick the application of the successor principle to a joint retainer case, and indeed the judge in question was Mr Justice Arnold, so he knew a thing or two about this particular area of law when he came to decide this case. As my ladies and lords will see from the headnote at page 172 of the bundle, this was a claim, an application for third-party disclosure against a solicitor under CPR 31.17, seeking 6 classes of documents, but the relevant one is Class E in the second sentence of the headnote, namely documents that were subject to legal professional privilege, and which prima facie prevented the claimant from deploying them as part of its case. That's a reference there to the inability of the successor to waive, exactly. And the point that is referred to in the headnote, the holding, is that the fact that the claimant could not waive the privilege and therefore could not deploy those documents in the claim didn't prevent an order for third-party disclosure being made. So if you like it, the specific point that was decided by the learned judge proceeded on the basis of, call it an assumption, but certainly an understanding or an accepted position that somebody who succeeds to a joint privilege is entitled to see the documents subject to that burden of not being able to waive them. And one sees that in detail, my ladies and lords, paragraphs 29 onwards of the judgment. In particular, at page 175, right at the bottom of the page, one sees who the parties are and in particular, who they succeed to. And one sees that Twin Benefits is contending that Ewan on the one hand and the other members of the class of the beneficiaries who Ewan represented, in particular Tom and Freya, were jointly entitled to LLP, and that was conceded, as one sees at the end of that paragraph. So it's Tom and Freya's joint privilege with Ewan that is in issue in this case, and Twin Benefits is the assignee of Tom and Freya's rights to bring this claim, and it is seeking the documents, a file held by a solicitor. Again, there's no analysis, particular distinction drawn between what are the allegations in the claim. It's simply because the Twin Benefits is the successor to title of the claim, he's entitled to the file that relates to that. And in particular, paragraph 31, the consequences that follow from that being the case is what I particularly rely on. Namely, that given that concession, that is a reference to the joint LLP concession, it's common ground that A, Ewan cannot rely on LLP to deny Tom and Freya or Twin Benefits as their successor entitled inspection of the documents, but B, Tom and Freya and Twin Benefits cannot waive LLP so as to permit inspection of the documents by the defendants without Ewan's consent. So you have at A and B the benefit and also the burden. And then the rest of the judgment just deals with the follow-on point, which is whether or not the fact that the claimant, Twin Benefits, is in that unusual situation, whether that means you can or cannot get an order for third-party disclosure. His Lordship held at paragraph 37 that they could. And I would also just draw your attention to this, that in this case, there were specific terms that the court ordered the disclosure of to enable the confidentiality to be preserved. Now, this is a case where, as you've heard, there were a lot of concerns raised by Travellers in this case. And so the way in which both the administrators and indeed Hugh James Invo-Legal sought to deal with those concerns was to offer undertakings. And effectively, they were prepared to offer any undertakings that the court might consider to be appropriate. And the judge considered those in detail, and they gave those undertakings. And the purpose of those undertakings was to protect the joint privilege that it was always accepted that Travellers had, to ensure that there wasn't any improper dealing with those documents, but at the same time to enable Hugh James Invo-Legal to obtain access to the documents, which is obviously what they succeed to in my respectful submission in this case. So that's Twin Benefits. I don't think I need to take my ladies and my lord to any other authorities. And those are all of them, except for the Winterthur case, which I'll come on to, obviously, in just a moment, make my submissions on that. But what I submit that those cases show is that although Königsberg can't be relied on in relation to bankruptcy, there's never been any question raised about the limitations of the principle, whether it applies only to sole privilege cases or joint privilege cases. There have been a number of cases which have applied it in joint cases, and that's exactly, so that's why I refer to it as a conventional proposition, that successor entitled principle is one of general application and applies both to joint as well as sole retainers. That then takes me to Winterthur. Now, my learned friends, I'm grateful to him for showing you, I think, most of the relevant parts of the judgment leading up to the critical bits, as it were. I agree with him that there's a particular, what's important in this case was the holding paragraph, I think it's 125, of the judgment of Mr. Aiken, which is at page 322. I agree with him that this is an important paragraph, because it is this paragraph that is then subsequently referred to in paragraph 134 of the judgment, which I'll come to in a moment. And in short, what the judge is saying is that you don't look at the deeds of assignment in order to understand whether privilege has passed, because privilege is a matter of law, it's not a matter of contract. That's, in my respectful submission, how one can summarise paragraph 125. And that's why, in short, this whole analysis about is there a clause equivalent to clause 6 in this case is really of no benefit to the court at all. It's not actually looking at the right question. The question is, has Hugh James Invo Legal succeeded to the title of transform? If my ladies and lords are satisfied that that is the case, then the privilege follows. And that is why one has two quite separate analyses of Mr. Justice Aiken's in this case, different analyses applying to the pre-ATE documents and then a different analysis in relation to the post-ATE documents. I agree with him, but they are conceptually different and hence different principles apply to them. I agree, Mr. Justice Aiken's deals with the pre-ATE documents from paragraph 127 through to 131. And the critical paragraph is paragraph 130.
So the pre-ATE documents, you say the critical paragraph is 130?
Yes. In paragraph 128, the learned judge points out that one is dealing here not with a joint retainer case, but a sole retainer case. And therefore, unlike our case, it's possible for NIG to simply waive any privilege in those if it wants to. That obviously doesn't apply here, so I can't rely on that. But what he then holds is he applies in paragraph 130, the successor entitled principle to the privilege of the assignor in this case. The assignor is, of course, NIG, and the assignee is, of course, Winterthur. And he relies not on clause 6 or any of those contractual rights. He simply says at paragraph 130, if there's an assignment of the cause of action in favour of Winterthur as assignee, then Winterthur stands in the place of the assignor. That's a conventional, in my respectful submission, proposition as regards assignments and the effect of an assignment. Here one is dealing specifically with an assignment of a cause of action, and that's what the principal reason I cited. I was the person who cited Winterthur to the learned judge, because it's a specific application of the successor entitled principle to causes of action and assignments of causes of action. Plus also, it's a specific application of the successor entitled principle to the documents on a solicitor's file that could relate to that claim. Again, there was no argument here that somehow the assignment was limited to specific parts of the file if one had to look at the pleadings in order to try and understand what had been assigned. None of that took place in my respectful submission because it wasn't relevant. The relevant question was, does Winterthur have the cause of action? If it does, then it's entitled to inspection of the court file, of the solicitor's file. And the learned judge then proceeded to say that in my view, an assignee is in a similar position to a successor in title. In other words, an assignee is a successor in title, my ladies and lords, in relation to legal professional privilege. And then he applies what he describes as the well-established principle that a successor in title succeeds to and is entitled to assert any legal professional privilege that was available to the predecessor in title. Now, interestingly, he applies two cases there, or cites two cases, Crescent Farm and Königsberg. Now, the implication of my friend's submissions is that somehow this is inconsistent with Königsberg, or that the learned judge declined to follow Königsberg. But of course that cannot be right, because he's relying on Königsberg, specifically in his application of the successor in title principle in paragraph 130. And I think that's all I really need to get from paragraph 130. Yes, so it follows from that, the last sentence, it follows that as between Winterthur and the panel solicitors, the latter cannot refuse to give the former disclosure of the pre-ATE policy documents. Now that, in my respectful submission, is exactly the situation we have here, where BLM have got files that belong to Transform. If Hugh James Imbo Legal is the successor of Transform, they're entitled to ask the BLM to deliver up those files. And BLM, applying the last words, cannot assert a privilege on behalf of it. Well, that's a different party's privilege. The tag claimants had no privilege to these particular documents. Then we move, my ladies and lords, to paragraphs 132 onwards of the judgment, to 138, where his lordship then addresses a different question, namely whether or not Winterthur could obtain access to the post-ATE policy documents. Now, there is no submission advanced in this case, and the judge simply therefore doesn't deal with the question as to whether or not the successor in title principle applies here. And really, once one appreciates that, the rest of it is about close analysis of words, but it doesn't really assist any further. The question that was addressed in paragraphs 133 and 134 was the question as to whether or not common interest privilege, that is to say the privilege that exists between an insured and an insurer, would enable Winterthur to obtain access to these documents. And the short answer is, well, of course not, because Winterthur is not the insured. There's no common interest that Winterthur has with the tag claimants. So there's no common interest that it has. And there was no argument that you could pass common interest privilege. It's almost a contradiction in terms. You could pass it in the same way that you could a joint privilege. So the analysis it simply doesn't flow. And as I say, the judge didn't address his mind to the question. What he does address his mind to in the last part of paragraph 133 in my respectful submission is the question as to whether or not under common interest privilege you can have a unilateral waiver of that, or whether it requires a joint waiver, as joint privilege does. And what the learned judge holds, I think he's been followed subsequently because there was some dispute between the authorities about this. What he holds is that common interest policy has, in common, double use of common there, not helpful, but has this similarity with joint privilege, if I can put it that way, namely that you cannot unilaterally waive it. It has to be by both parties. And that, so he's not addressing his mind in that submission to the issue that this court has to grapple with. In paragraph...
So you say there's a common interest privilege has this similarity with joint retainer privilege. It can't be waived unilaterally.
Yes, or at least this particular common interest privilege, because I've cited Hollander on this particular point in my skeleton argument, and the way Hollander describes common interest policy privilege is a sort of amalgam of different principles that can apply in different factual scenarios. So it could conceivably be the case that you can't have a unilateral waiver in certain cases of common interest privilege, but you could in others. I think there are some cases which hold.
Your point on that is, and that's an issue that we have to decide, therefore, is whether Mr Lynch is right to say this effectively is treating them both the same, or your point that this is simply a point that they have in common.
Absolutely. Well, that's right. I'm grateful. And in paragraph 134, what the judge is doing there, he uses the words, as I have already stated. That, in my respectful submission, is a reference back to paragraph 125 of his judgment, where he says, well, you know, there's no question of it simply passing by contract. You don't pass privilege by contract. But that's of no assistance either to, in my respectful submission, to my ladies and lords. And then once one deals with that particular part of the judgment, the rest, in my respectful submission, it doesn't actually address the question, again, that the court has to deal with. As I stated in my skeleton argument, there is no argument here that there is a right of access which is passed by virtue of the assignment. That something similar to clause 6 arises. I just don't advance that argument. My case stands and falls on the successor entitled principle. So those are my submissions on the authorities. For what it may assist my ladies and lords, I've also provided you with all of the extracts from all of the leading textbooks. And I'm not going to tediously go through them. I doubt that would assist you. All I will say is this.
This is an area where Queen's Counsel, who do this sort of work, they've all written books. I mean, it's a really quite small group of you that haven't. It's only in relation to disclosure. The only point I was going, we've got these, and speaking for myself, I don't need you to take us through them, but the only point, I think, as is often the way, it's quite pithy in Hollander about joint privilege and those sections. I think it's section 19 of the book, or chapter 19.
Yes.
I think you cite some bit of that, but that whole bit I found helpful.
I would respectfully agree with that, my lord. And I would also draw your attention to this, which is the point which I drew attention to the judge below as well. If it was the case that the Winterthur case overruled or failed to follow Königsberg, one would expect to see in Mr. Hollander's own book some reflection of that, or at least some doubt expressed as to the application of the successor entitled principle. His whole section, paragraph chapter 19, is about joint privilege.
This is tab 23.
Tab 23, page 455.
Yeah.
His whole section on this is about joint privilege. So it's if you like, it's exactly on the point. It's not dealing with privilege generally, sole privilege. It's dealing with joint privilege. And Mr. Hollander doesn't even cite, in this particular paragraph, where he's dealing with 1901 with the principles, he doesn't cite Winterthur. Similarly, over the page at 457, 1905, he doesn't cite Winterthur there for the proposition that he advances in that paragraph. He cites Crescent Farm, he cites Surface Technology, and he cites at footnote 17 Leeds and Nemos and Königsberg. And he therefore seems to endorse the proposition that the submissions that I've advanced, that Königsberg is at least good law on the joint retainer point, and it hasn't been overruled. And Schlossberg and Leeds don't alter that analysis either. Where he does cite Winterthur is, and that's why I've given you paragraph 1906, in page 458 of the bundle. He cites it there for a different proposition, in particular in relation to contractual waiver, which I submit does provide some, albeit not conclusive, support for the submission, I would advise. Just on that, the most up-to-date book is, of course, Phipson, which is behind tab 27. And I think that this is basically a cut and paste from Mr. Hollander's own work. I draw it to your attention because it's actually published in 2020. And indeed, it cites the first instance decision, which is under appeal as well, as support for the proposition. If I could just draw your attention to page 487.
487.
487 to footnote 1. One sees, in addition to Königsberg, Crescent Farm...
Sorry, just so that we're clear. So 486 is the cut and paste?
Essentially, yes.
Persons who grant a joint at
Yes.
that point.
Yes.
And then 487
is the footnote. And in addition to Königsberg, Crescent Farm and Surface Technology, Mr. Hollander, I think, is the editor of this particular part of Phipson, also cites Transform.
Well, he'd have quite a good case for intellectual property theft if he was not the author of Phipson.
I think so. It's not my expertise, but I called it a cut and paste, so I obviously have a view.
Yes.
A view
All
on
right,
it.
that's very helpful.
And ladies and lords, I don't think there's anything I need to add to my submissions on the law on the first issue. If I move on then to the two alternative arguments, the learned friend advanced. His proposition is that even if I'm right on what I understood to be the applicant of the appeal, he would like you to interpret the assignment in this case as somehow limited, namely to exclude, as I understood it, the successor entitled principle. And that argument is a pure question of construction of the, as I understand it, of the assignment itself, namely the separation, if you like, between clause 1.1 and 1.2. And of course, if I just ask you to go to the assignment, which is core bundle, tab 7, I showed you that before. I showed you the paragraphs A to J. I didn't address my ladies and lord on this particular point, page 116. I emphasise the breadth of the assignment as to what the assigned claims were before. I drew your attention to the fact that it was an absolute assignment. That is to say, not limited or qualified in any way. And I also drew your attention to the fact that it was not limited to simply what the claim that had been issued, but any and all claims that might subsequently arise. And it's in relation to the conduct of the defence of the potential defendants of the litigation. It's clear in my respectful submission that it must apply to all of the files. Just looking at that. So the only argument that I'm then facing is an argument that somehow the provision that follows limits that assignment in some way. And that's a submission which I have to say, there's certainly on the wording, the clear wording of the document, doesn't purport to limit the assignment that takes place in one. They're just dealing with two different things in my respectful submission. One is dealing with the title to the shows in action. That's what's being dealt with at one. Two is just about a right of access, a contractual right of access. Now, if the existence or otherwise of a contractual right of access or a clause dealing with a rights of access didn't qualify the successor entitled principle in the Winterthur case and didn't in the surface technology case, why on earth would it here? There's no
Just
support.
reminding myself of paragraph 25 in surface.
Yes. Yes. Why on earth would it here? And it just doesn't even actually purport to limit anything. As I say, it's just a contractual right of access to the Now, I would add to that the analysis that comes from Winterthur and also that comes from Avon, which is that privilege is not about the parties' agreement, it's a question of law.
Actually, that comes first, doesn't it?
I suppose.
On your submission,
Yes.
that would be the first point. You'd say that effectively you don't get, if you're right about argument 1, you don't get to argument 2 because it arises through the assignment of the cause of action, and so effectively it doesn't matter what, as long as the cause of action is assigned, it doesn't matter what the deed says.
Absolutely, I'm grateful.
Because it's not separately susceptible to agreement.
Absolutely. And how could it be? How could an agreement between, I rhetorically ask, how could an agreement between Transform and Invo Legal pass privilege, a joint privilege, which somebody else is a party to? In Winterthur, the reason why that was relevant, the contractual provision, is because there was a separate agreement between NIG and the tag claimants. You can't buy two third parties cannot somehow affect the privilege of the insurer in this case. It just simply can't. So in my submission, there's nothing in this additional point, and the wording in its, as I say, on its own doesn't indicate that there's any qualification. It's an additional contractual right which wouldn't be restricted at all to the documents which are under consideration. Actually applies to any and all documents which the administrators either have in their possession or in their control that relate to the defence in the litigation. So it goes much wider than that. And it's entirely permissive in its object and in its wording. So that just, in my respectful submission, leaves the last alternative that my learned friend put forward.
You dealt with that first, actually.
Well, yes, I did to some extent. Yes, I did. I did to some extent. But I would just
add to it. But
yes, I would. Yes, I did. Yes, I just add to it in this way. There was a time when it did look like there was going to be a sensible commercial resolution to this issue. That is to say, when originally there was correspondence between Transform and Travelers, Travelers did say that they were happy to deal with this in a pragmatic way. The administrators said they were happy to give whatever undertakings were reasonable to allow that to happen. But then, as you may have seen from the, and I don't want to go into the partisan bit of this case, but you may have seen there was a change of position. For whatever reason, whether that was right or wrong, there was a change of position. When Travelers got to the hearing before the learned judge, its position was so extreme. Not only was it claiming privilege over every document in the file, but it was saying that no undertakings could be devised that would protect its position. It was simply impossible, and that it didn't need to give any reasons to justify its position. That it was because it was a fundamental right. That's the beginning and the end of it. That argument failed before the learned judge, but there was also an argument about keyword, a fallback argument, and I'm not sure if you picked this up in the skeleton arguments. As the hearing approached, further evidence was served by Transform, adopting a position that following the Supreme Court's decision, the whole claim was bound to fail, and therefore there should be a limiting of, there should be a variation of the original order which had been agreed, that was made by ICC J. Jones some 2 years at that point before, for the documents to be provided to the administrators. At that point, not only was Transform position that they shouldn't be provided to Invo Legal, but they shouldn't even be provided to the administrators. And it was in that context that they said, well, it's now, and as a result of the Supreme Court judgment, there should be a completely new system put in place with keyword searches, because the administrators didn't need to see all these documents. So although it's not the same argument, I accept that, but what it shows is that we have been around this particular block before. The learned friend did suggest keyword searches as an alternative before the learned judge. He hasn't appealed any part of that judgment. The learned judge you would have seen, although it wasn't the subject of these grounds of appeal, so you wouldn't, my ladies and lords, have paid great attention to that part of the judgment. But the learned judge rejects the submissions that were advanced that somehow the Supreme Court decision sweeps away the order that had been made by Judge Jones. And I mean, I haven't had any chance to speak with my learned friend about this, but the idea that after, I think it's now approaching 3 years since the administrators actually wanted these documents. And given where we are now in terms of the claim, the fact that it's had to be issued because the limitation wasn't extended, the fact that it's had to be pleaded based on the information that the claimants had, none of these documents will be passed on to Invo Legal because of the stay that exists in this case. The idea that we're going to now engage in an argument about what the pleadings say and what issues are relevant to those pleadings, and then extract from that the relevant documents in circumstances where it took BLM and Travellers 2 years to go through these documents is unreal in my submission. It's just not a proposition that the court should entertain. Those are submissions.
Can you just help me with this? It's probably again not relevant, but just for my own slotting together the bits of the jigsaw. If the Supreme Court had upheld the Court of Appeal in the Section 51 application, that would have made a significant difference to the underlying claims here, because it would have removed the costs.
Yep.
On your submissions this morning, it wouldn't necessarily have taken away everything, but if the Supreme Court had upheld the Court of Appeal, everything, as it were, would have then had to have been reviewed.
I'm not sure I would accept that as a proposition, because
I appreciate that
would obviously have an impact, a major impact on whether
this claim had started.
Yeah.
I get that, because one of Mr Lynch's complaints, in the background, is that that effectively they were on opposite sides, and then there was the assignment. So I appreciate that on the timing the claim had started by then, but it would have clearly had a major impact. But you say you couldn't go as far as to say you accept that the claim wouldn't have been made.
No, I don't think that's right.
So we can level a good deal of the blame at the Supreme Court, but not 100%.
I think if one looks at just at the dates, the assignment preceded the.
I follow that.
You've got that.
The date.
And the way it's expressed is that it's an unlimited claim. I mean, of course, the result of the Supreme Court's decision is that the damages are much greater than they otherwise would have been.
Yeah.
It doesn't follow from that the issues would have been any different, save perhaps any specific issues that relate to the costs. But I don't.
But one of the ironies, although Mr Hubble might not accept it's an irony, he might have a more stronger word, but one of the ironies is that one of the reasons for the Supreme Court case was that there was no legal obligation to disclose the insurance position.
Yes.
And his clients are now effectively in the firing line for failing to disclose the insurance position. So there's
Although
it's quite interesting that the underlying points in this case are quite interesting, but they're not straightforward.
They're not straightforward.
No. Sorry, I appreciate that's probably entirely irrelevant to what we've got to decide, but I just was trying to tease that out.
There are lots of nooks and crannies and different analyses in this case. I would accept that entirely. I'm grateful.
Thank you, Mr. Bond. Now, Mr. Hubble.
I have two short matters on which I'd wish to address you, if I may.
Yes, please.
The first is, just picking up on Lord Justice Coulson's point, is I think part of the conundrum about the underlying professional liability action is the uninsured claimants were never going to get paid by Transform because there was no insurance, and Transform, it seems, did not have adequate assets. So the magic, if I can put it that way, of the assignment is there is now a claim brought by HJI as Transform, standing in the shoes as Transform suing its client. Because uninsured claimants, of course, weren't clients of BLM. And it's the claim, so it's put, is on the assertion that Transform would never have been exposed to the judgments because the uninsured claimants would have given up if they'd known there wasn't insurance. But if you look through the assignment, you have the oddity that a recovery is going to be made on behalf of uninsured claimants and lawyers in respect of an enforcement of an underlying claim which never would have been enforced because there wasn't insurance. And I think that's what makes it quite difficult to get one's mind round, and will give rise to quite a lot of interesting arguments in due course.
Yeah, no, I mean that
It's all run and
Already has.
Yes.
that was the
you'll all
point
have
I was.
retired by the time you finish.
That was the point I was ineptly trying to skewer this morning. But
Yes.
I do understand that.
So, and then the second point, if I may, 3 points have emerged in the cases. The point of principle, there's the question of the assignment and how it works, and then there was the question, the third point that arose in my friend Mr Lynch's submissions about documents relevant to the cause of action, which is the third point. I'm neutral, and I have no submissions to make in respect of points 1 or 2, and I don't make positive submissions in respect of points 3, but can I identify some practical issues that may arise if this court were to descend to that level of detail? And the administrators and travellers are not parties to the professional liability action. My client is a party to professional liability action, and if these documents are provided to HJI as successor entitled, then I assume they are going to be deployed in the action. It strikes me there may be an unresolved issue as to whether HJI is entitled to deploy them, or whether that is...
But that seems to me to be another area of satellite litigation.
Well, whether
inevitably, actually, I would have thought.
Well, it gives rise to the question about whether HJI can unilaterally waive the joint privilege.
Mm-hmm.
But I'm not making a submission. I'm just identifying the things that may happen down the track in the underlying professional liability action, which would mean that this court really should stay at the level of principle and not engage in what is or isn't a relevant document.
Well, I confirm my ladies and I on that identified that point when we were talking about the case this morning, because that's also a point that arises in twin benefits.
Yes.
Where you've got the disclosure, but even if you've got disclosure, then the question is deployment.
Yes.
So that is definitely, I would hope you would agree with this, Mr. Hubble, that is definitely not for us.
Well, that's really the submission I'm making. Is I'm
No,
giving you
well,
examples of reasons why you should not get
Oh,
involved.
well, I think that we're becoming more and more conscious of the landmines that are strewn in front of, all of you, but
perhaps
us as well.
Develop that very briefly.
Of course.
Either, in fact, they can't be deployed, or there's a row to be had between Travelers and HJI about whether they can be deployed in the underlying professional liability action. Or the other alternative is that they can be deployed. Well, if they can be, then that's a Lillycrap and Lauder waiver, and my client would be entitled to address relevance and what documents it wanted to deploy in its defence. And of course, what's relevant is not determined by how the claimant puts their case in a particular claim on breach. What's relevant is what the issues in the action are when one looks at the particulars of the claim and the defence and all the issues that arise in respect of breach, causation and loss. So the question of relevance is a two-way street. Mm-hmm. It's not something that can sensibly be dealt with through the eyes of a claimant or the assignor or the assignee. And I'm very conscious, for instance, that leading counsel, who's the other defendant of professional liability action, isn't even in court, and no doubt may have submissions to make in relation to that sort of question. So really that's a snapshot to give you an illustration of the sort of issues that may develop in due course, and why this court, if I may respectfully say so, would be wise to keep itself at the level of principle
I think
we've actually been asked to resolve.
But Ms. Hubble, I think the reality is we were momentarily tantalised by the prospect of there being some pragmatic solution to at least part of the case.
Yes.
I think we've all retreated from that.
Well, that's all I wish to say, my lady, unless there's anything else that I can...
Thank you very much, Ms. Hubble. Anything in reply, Mr. Lynch?
My lady, I'm grateful. Sorry, I just quickly need to rearrange.
Oh, no, of
Matt,
course.
if I could just
Do.
have one
Take your
second,
time.
please. Thank you. I'm grateful. If I could just respond on some points on the authorities, recognising obviously the court's heard a very full day of argument, so I'll be as brief as I possibly can, and then some short points on the substance. So if we just have a very quick look at some of the authorities, please. If we go to minutes at AB 21. And one of the key points I'll make on minutes, Pickering, Crescent, Aegis Blaze, and a number of the others, is a point that it may be that there's nothing between my learned friend, Mr. Boardman, and myself. I'm not sure. I say that the scope of privilege that travels with the transfer is determined by the transfer, the ambit of what it is that is transferred. So, taking no doubt ludicrous example, in this case, HJI is not entitled to transformed privilege in a separate action. So, a tax liability case, for example, some other separate litigation that is just separate to this. So we have to look at what is transferred, and that sets the parameters for the privilege that transfers, if that makes sense. That's the obvious basic point. So just looking at Minute and Morgan, please, at tab 21. Just very brief reference at the bottom of page 429. And my learned friends completely appropriately taken the court to this. We see right at the bottom, 4 or 5 lines up, we see the words, with reference to questions connected with the matters in dispute in this court. And obviously, in all of these cases, it could be a very broad application of the principle or very narrow. It's just going to depend on the facts. It's as simple as that. And so that's the point I wanted to make on Minute. On Pickering, we see, that's at tab 19, we see that the page 418 to 419, and also page 417, again, the bits that my learned friends rightly taken the court to, it's the specific transfer. Here, the books of partnership in which the plaintiffs, as well as the executors, deceased partner and surviving partner, has an interest. So it's always focusing in on whatever it is that's the transfer, and it's an obvious thing to say. Re Crescent Farm, there might be a dispute between my learned friend and myself, I think, on this, because here, I think it is clear that it's very narrow and specific. So we see this, tab 17, page 390. We see here at the bottom the part we've already gone to about the enclosing of counsel's opinion and what was sent with the title documents. And then page 393, B through to D, where we see the claim for privilege is so made in the list of documents in these words, such documents professional communications of a confidential character passing between the first named defendant, solicitors, counsel, for the purpose of obtaining legal advice in relation to the title to land now vested in this defendant. So that is the narrow.
Well, I don't quite understand this. The principle is a def. There's the principle. And then you apply that principle to the particular facts of the case.
Yes, my lord is absolutely right.
Principle isn't limited. Principle is, according to F, completely unlimited. That you then apply it to the facts of the case. It's that way round.
Yes, and my lord's absolutely right. All I really mean is that we see, well, in a sense, there are two principles. One is that is the principle. Privileged predecessor entitled does inure of the benefit of successor, but successor to what? So that it's just it's just continuation of explaining successor is shorthand for successor to whatever it is, and as it happens in the Crescent farm, it was relatively narrow, and there'll be other cases where it's relatively broad, or of all different kinds. There's no limitation on that. And my lord's absolutely right. That is the principle. Will depend on facts. So in the Aegis Blaze, which you don't need to dwell on, my learned friend didn't dwell on, at tab 16, the document in question was based on specific documents, and it was a limited application in that case, just on the facts of that case. And my learned friend didn't go to that, so I won't go to it in any detail. In re Königsberg, please, at 14, tab 14, the key point that I would make in response to my learned friend's submissions on this case isn't on the point I've just been making, but on a different point, which is the point made by my Lord Etherton in Schlossberg, which is that this case obviously predates the relevant authorities on fundamental privilege. And so my learned friend's right. What is wrong about what's been found to have been wrong is the specific point about the successor and title in the bankruptcy context. However, there's another problem with it, which I would submit is more fundamental, which it simply doesn't grapple with the issue before the court today, because there's no proper argument, because it went by concession, about the impact of joint retainer in the successor and title context. The third issue is the point I've already made, which is that the case simply predates the relevant authorities. So the short point is that one can't get too much from In re Königsberg for today's purposes. Surface technology, if we look at, please, at 12, here, my understanding of this authority is that it is limited in terms of the application of the successor and title principle to the specific facts of this case. And sorry, I'm not explaining that particularly well. What I mean is that this isn't a sort of open book, anything goes, once the door is open to successor and title, it's open to everything. And we see that if we pick it up at 19 on page 337, please. So we see here, this is the summary. I should take the points in order, starting with privilege. It seems to me, following from the decision of Goff J in Crescent Farm, that the successor and title to identify property is entitled to assert the privilege of the vendor, at least in respect of documents prepared for the purpose of obtaining legal advice in relation to the property transferred and in relation to the advice given. And that's a very accurate and helpful summary of the point that I'm making much less clearly, but that's essentially my point on that issue. And then, so we see that at 25, at the beginning of 25 in this same authority. Obviously, the first question is what was transferred to the claimants in this case? Undoubtedly, it seems to be intellectual property insofar as titles subsisted to it, including the patents in the vendor owned them. So it seems to me the claimants can claim privilege to this extent. And we then see 27, just need to look at the beginning of 27. As to the claim which arises on the basis of the communication of confidential information, it seems to me that this question should be determined first on the construction of the agreement. And so it's just that another example of how each case will depend on its facts. And in this case, that's how I understand the court to be addressing this issue. Again, similar difficulties with relying on surface technology. 1, it relies on Inri Königsberg. 2, and more importantly, the authorities before the court today were not argued before the court in surface technology. In fact, it seems that there's very little, if any, real argument on the issue before the court today. So again, it's not of a huge amount of assistance to the court as an authority. If we look then at Schlossberg, just briefly, please, there's just one point to pick up, please, that's tab 9. And it's paragraph 68, but that will be on page, sorry, excuse me. Yes, so it's page 235. So page 235, it obviously starts at paragraph 65 and just running down the page. Obviously, this is in the context of expressly dealing with section 311 of the Insolvency Act 1986. We see here that there is reference to surface technology at the end of paragraph 68, obviously in this specific context. And then, as we've been to already, paragraph 70 and 71, the applicable principles are, once again, those stated in the Derby Magistrates case, the Sims case, and Morgan Grenfell case, keeping in focus the status of privilege as a fundamental right. And then 71 is not, however, necessarily implicit that the trustee can waive bankruptcy legal professional privilege and taking steps against third parties to benefit the practical state, as desirable as it might be from the point of view of the creditors, echoing the words of Lord Hochhauser and Morgan Grenfell case quoted at paragraph 49. The fact it would have been sensible or reasonable Parliament to include such a power does not mean that it's necessarily implicit, having regard to the express language of the statute. Obviously, my point isn't to make any point on section 311 or a construction point on that. It's just that the reasons behind Sir Terence Atherton MR's decision are those other cases. And so that's what the Travellers would submit particularly important to have regard to in this case. Then, just briefly on Leeds and Lemos at AB7. It's paragraph, sorry, it's just taking a second to find, excuse me. Yes, so it's, my learned friend took the court to page 159, paragraph 232. And again, it's really an endorsement here, paragraphs 233 to 234. It's, as my learned friend rightly pointed out, an application of Sir Terence Atherton MR's decision in the Schlossberg case. But again, it's a reference to the reasoning behind it, not simply the decision. And that's important, Travellers would submit. And then over the page to page 161 at paragraph 244, please. It is important here, the point made about Crescent Farm, which is Judge Hodge QC making the point. I point out that even on that basis, Crescent Farm is no authority on the issue of who has the right to waive privilege in such documents as distinct from asserting it. That is not the same as the present case, but it's a parallel, because here HCI would be taking and then waiving in the sense of seeking to, first of all, hand them to Hugh James, but then also deploy them. And so it's not the same. Sorry, my lord,
This isn't nothing to do with waiver.
my lord, I accept that's right. I simply I'm drawing a parallel. It's not the same, and I'm sorry if I indicated I thought it was the same. I didn't mean to. Twin benefits, just only briefly, hardly need to look at the authority. It's behind tab 8. There simply wasn't any argument. It just doesn't assist.
Well, that does suggest, therefore, you are saying that Mr. Justice Arnold missed it.
My lord, no, because it appears, I don't know, but it appears to have gone by agreement.
Well,
and
I have slight difficulty with that, just so you know. It, on one view, twin benefits is simple and clear. I appreciate you say, well, they made a concession, but that was wrongly made.
There might be any number of reasons why the concession was made. We simply do not know.
Yeah.
It may have been absolutely right in the circumstances of that case for any number of commercial reasons. I simply don't know. But what I say to the court today is a concession was made and there was no argument. And it would be difficult, I imagine, it wasn't in the case, but for Miss Justice Arnold to raise the point for argument when it went by concession, I suspect that would not have been in the judge's mind. Obviously, I can't speak.
If it led to an unlawful order.
My lord,
he was leading counsel in surface tech. He was certainly familiar with it.
and my lady, is
Yes,
that
Justice Arnold.
yes, my lady is absolutely right. But we simply don't know is the point I make. There's no argument. We don't know why a concession was made. Concession was equally wrongly made in the Inri Konigsberg cases. These things happen. Whether it was rightly or wrongly made, Traveller's point is it was made, and therefore there's no argument, and therefore it's not of assistance. Then on to Winterthur, please, at tab 11. And if I could just start, please, with, and I'll only be brief on this, page 321, paragraph 118.
I have been through this quite extensively.
My lady is absolutely right. I just want to make one very short point.
Certainly.
So it's paragraph 118. The point is that Winterthur took as assignee of NIG the shows in action. And privilege, whatever, and on my learned friend's case, that's whatever privilege runs with or travels with the shows in action would travel to the assignee from the assignor. It was found that there was common interest privilege in this case, and one would expect, were the SIT principle to apply as my learned friend puts it, that would also travel with the assignment. But Mr. Justice Aikens obviously found it did not, or if it did, sorry, more accurately, if it did, the claimants, the other holder of the CIP, were entitled to say no. So there is, in Traveller's respectful submission, a direct parallel. It's not absolutely on the same facts, of course, but that's why we see at the end of 137, page 325. Secondly, it also means that, as between Winterthur and the tag claimant, the latter cannot enforce its common interest privilege that it would otherwise have had with NIG. And so it's that, in Traveller's respectful submission, explains, and the whole passage from 132 to 138, explains that there is a direct parallel with the circumstances in this case. Just to give the court a reference, that there's a passage in the textbooks at tab 23, page 459, about the close relationship between joint privilege and common interest privilege. On the textbooks, all I would say on the textbooks is that textbooks only go as far as they go. They simply address what they address. It's helpful sometimes as a summary, often helpful as a summary, but here the textbooks simply don't engage with the issue before the court today, and so they are, again, of limited assistance. So that's all I wanted to say about the authorities. Thank you. If I could then just make some brief points in response to my learned friend on the points of substance, on the facts. In terms of the construction argument, so looking at the assignment at page 116, we see the assignment, all claims, shows, and action, rights whatsoever, which Transform has or may have against potential defendants, arising out of concerning the conduct of defence, the assigned claims. All I would say is that what we then see is the claim very clearly articulated. We see it in, first of all, there's a pre-action protocol notice, and this is in the Respondents' Appeal bundle at page 12. Oh, sorry, it's page 17. Sorry, I apologise. So we see it's page 17, and this is dated 6th of September 2018, so shortly after the assignment. And we see here, just jumping through it, paragraph 2.4 is a reference to the Court of Appeal's decision about the non-disclosure of the insurance position, and 2.7, liabilities incurred as a result of this judgment flow directly from BLM's negligent advice. So this notice, early notice, that's back in September 18, was about the specific point about non-disclosure of the insurance position. We then see the letter of claim, page 41, makes the same point. We don't really need to go through that, just for the court's reference. It is at page 41. And then we see page 118, the particulars of claim. Again, the cause of action that's now been clarified. There's no suggestion of any other claim. That there never has been another suggestion of another claim. And my learned friend makes the point that HJI don't have the file, so they can't tell. But the original client was Transform. So if Transform thought there was another cause of action, they're the ones who, since whenever it was, 2012 onwards, would have thought, well, we've got another cause of action. And so, yes, HJI haven't seen the files and haven't reviewed them, but equally, Transform certainly has, and this is the only claim that's ever been intimated. So, in reality, it seems very likely that this is the only cause of action that will be transferred, and certainly the only one that has been. In terms of the construction of 1 and 2, I'd only add this one oddity, which is that under 2, there's an agreement to provide reasonable access to documentation. And under 1, if my learned friend is right, then 1 gives access to material that cannot be given under 2. And it's, but the court has most submissions on this. 2 is the more specific clause in the normal way of construction. 2 is the specific clause dealing with disclosure. It doesn't overrule 1, they just do different things. And the court has my submissions on that already. Finally, on the particulars of claim, in response to a question from my Lord Justice Coulson, my learned friend addressed the causation issue, so it's the Respondents' Appeal bundle, page 118. It's important to note how causation is put in that claim. And that appears at the bottom of page 147 through to 150. And my Lord Justice Coulson made the point that this raises the potential question as to whether or not the claims are good in the first place, because the point is the claimants would never have brought the claims. But the way it's actually put, page 148 onwards, is that the claims would not have been brought, not because they were bad claims, but because there's no money to go after, because there's no insurance. So the actual cause of action transferred is narrow, and narrow on that point also. It's not broader than that. Sorry, just be one. If I could just have one moment, please. I apologise. There were just some final points made by my learned friend, which I'm I will reply to only briefly because they were made. I hope it's appropriate to do so, but I'm not sure they'll really determine anything. But the point that Travellers claim privilege over the whole file, Travellers only claims privilege over the privileged material. That was the basis of the application. And just for the court's reference, that's made clear in terms in Travellers' own application back in February 19, which starts on page 30 of the supplementary bundle and page 31.
Just give me a moment.
Sorry.
Supplementary bundle 31, did you say?
Yes, please. And so that's just the second page of Travellers' application. Just to make clear, it's trying to protect its privilege. There's just a hint of a suggestion that Travellers was taking an unreasonable position. The Travellers, what? Pardon?
Have Travellers then disclosed all the documents that they say are not protected by privilege?
No, they've offered to do that.
We're just getting into all the stuff that we've tried so hard to avoid.
Yes. And my Lord's absolutely right. I'm sorry.
I'm sure that you've got a note there from your clients with a whole load of points you want to make. My strong advice would be to exercise judgment in relation to the points that you make in relation to that. Because, for one, speaking entirely for myself, I don't think I'm going to be assisted by the nitpicking we've tried so hard to avoid.
My Lord, I'm grateful for the guidance and I willingly accept it. And I apologise for having got
gratefully accepted.
Gratefully accepted. And I apologise for having got down into the unhelpful weeds.
It's very...
if I could just check
please,
my notes.
Miss Lynch, it is very difficult in a case like this.
My lady, I'm grateful. If I could
just want to check your notes.
If I could just have,
please do.
I'd be grateful.
Please do.
Exercising judgment, I will not reply to the points made towards the end of my learned friend's submissions. There is disagreement. It does not, I think it will not assist to go through that now.
I think we're very conscious that this is litigation that has become extremely fraught.
I would make one point in response to that. I have to say, it normally takes a few minutes between my learned friend and myself, and I'm not attributing blame anywhere else, but I think there is a way through that is helpful and always courteous, and I'm grateful to my learned friend for...
Perhaps your respective instructing solicitors lock you two in a cupboard and leave you there to do some...
My lady, I'm grateful. And when I make that point, I in no way blame any instructing solicitor or anybody. It's just sometimes a face-to-face conversation produces results in a way that's...
One of the difficulties of the last year is that just doesn't happen.
My lady's absolutely right. If I could just have one moment, please, to...
Of course you must.
Excuse
your
me.
junior counsel being making notes assiduously.
I'm grateful. And if I could just, I'm afraid, take instructions electronically as well. Would that be convenient? I apologise for that, but there's no other way of doing it.
No, I understand. Yes.
My lady, I'm grateful. My lady, I'm grateful. I apologise for turning my back in that way, but I'm afraid it's hazard of the modern day.
Fit so many people in the court, so you've got to take instructions how the best we can.
My lady, I'm grateful. And unless I can help anything further, those are submissions in reply.
No. Were you hovering?
No.
Thank you. Well, thank you all very much indeed for all your submissions. We're conscious not only that this is a very difficult and fraught matter so far as the individual parties are concerned, but also certainly it's indicated it has wider implications. So it won't come as any surprise at all that we'll be reserving our judgments. We'll hand them down as soon as possible, but I can give no indication at the moment when that will be. They'll be handed down, I'm sure, electronically. Although we've had the privilege of a face-to-face hearing, I can't think we'll be handing down face-to-face anytime soon. You'll be sent draft orders, draft judgments in the normal way. If you could reply with normal typographical, grammatical or minor factual errors. Perhaps I ought to say in the context of this particular case that it won't be an invitation to treat, however. I hope then you'll be able to agree any orders outstanding, any outstanding disputes between them we would deal with in writing, in particular anything relating to costs. So unless there's anything else that we need to deal with today, I thank you all very much. Thank you, Junior, and for all the parties that I know are as equally involved and have worked just as hard on the case, who have only been able to attend by live streaming. Thank you all very much.
All right.